If you've got a job with a boss and a strongly held religious belief, the Supreme Court issued a ruling today that you may want to keep in your back pocket. And believe it or not, the justices were unanimous on this one. In today's ruling, the Supreme Court created a new rule when it comes to when an employer can deny your religious accommodation. Since the late 1970s, the law has said your employer can deny your religious accommodation of your strongly held religious belief if the employer was able to prove it would create an undue hardship to the company. Now, most people interpret undue hardship to mean more than just a minimal cost. I know. That's really vague. So now this new rule the justices created today says religious accommodation requests should be granted unless the employer can show that the burden of granting an accommodation would result in substantial increased costs in relation to the conduct of its particular business, and that takes into account all relevant factors in the case at hand, including the particular accommodation at issue and their practical impact in light of the nature, size, and operating costs of an employer. Still pretty vague, but a little more employee-friendly. I first told you about Groff versus DeJoy in this video back in April. Gerald Groff is an evangelical Christian who was a postal service worker. He refused to work on Sundays because of his strongly held religious belief. USPS tried to make accommodations for him, but in the end, those accommodations weren't good enough and Groff resigned. Then he sued USPS, saying that the Postal Service violated Title VII of the Civil Rights Act, which makes it unlawful for an employer to discriminate against an employee based on religion. Justice Samuel Alito wrote today's majority opinion, and every justice signed on, saying the previous test established back in the 1970s that said a company only needed to prove that undue hardship to deny your religious accommodation was flawed from the beginning. But brace yourselves. Legal experts are expecting a wave of lawsuits from employees testing what exactly this new rule means.